Good afternoon. Thank you for joining us. We are putting on a joint SWCA Holland and Hart webinar on Clean Water Act regulatory updates. This will look at waters of the United States and pending rulemaking, as well as the new nationwide permits. A few items of business before we get started. One is that this webinar is being recorded, so if you want to re-listen or share this with your colleagues, there will be links available on SWCA.com as well as YouTube. There will also be links sent out to all registered attendees following the event. Your microphones are muted and your chat feature is turned off. If you have questions that you'd like to ask of any of the panelists, please do that through the question and answer button on the Zoom window. And we'll try to answer as many questions as we can at the end of the webinar. Also, the information we're providing is intended to provide a very high-level overview of these pending regulations and rulemaking process. This is not intended to be a full and exhaustive assessment of these matters. If you have detailed questions where you're trying to make business decisions on how to move forward, please reach out to your trusted environmental consultants or attorneys or in-house colleagues who are informed of this matter. So today's panel consists of myself, Noah Greenberg. I'm a technical director of water resources at SWCA. I've worked here for 3 years. Prior to that, I worked at a water resources engineering firm for 11 years. I'm joined by Bonnie Rogers as an additional moderator. Bonnie's based out of our Pasadena office and is an aquatic ecologist who's been with SWCA for a little over 1 year. Prior to joining SWCA, Bonnie worked for the EPA for 2 years and at the Corps of Engineers for 7 years. We have Daniel DeJoode, who's a aquatic ecologist and wetland scientist based out of our Minneapolis office. Daniel's been with SWCA for about 6 months. He has a PhD and he's extremely knowledgeable in wetlands and wetland regulations of the upper Midwest. We're joined by Ashley Peck, who's a partner at Holland and Hart. She's been with Holland and Hart for 8 years and has experience prior to that. Ashley has a bachelor's degree from Colorado State University and her JD from the University of Washington. And finally, we're joined by John Heule, who's been with SWCA for a little over 6 months. John is a senior project manager in the Denver office and specializes in wetland permitting, wetland science, and associated permitting.
Hi, I'm Bonnie Rogers. Today, our agenda is 3-part. We'll be starting with a regulatory update lightning round, followed by our panelists for about a half-hour discussion on topics such as Clean Water Act regulations, the upcoming 2022 nationwide permit program, jurisdictional considerations, legal outlooks. We'll then have a moderated discussion followed by a few key questions from our panel to our panel. And if we have time, we'll answer some of your questions live today, or we can follow up with you individually afterwards. First up, we have Ashley Peck. Ashley is an environmental attorney and regulatory specialist from Holland and Hart. She's out of our Salt Lake City office. Out of Salt Lake City. Ashley has over 15 years of experience supporting clients and projects related to Clean Water Act. She'll give a summary of waters of the U.S., how we got here and where we are today. And with that, Ashley?
Thanks, Bonnie and Noah, and thanks to SWCA for having me. As the lawyer on the panel, I'm tasked with covering about 30 years of legal wrangling over the Clean Water Act in a short period of time. So like Noah said, my presentation will by no means be comprehensive, nor would you want to sit through all of that. But I want to go over the highlights of what got us here. Because it's important for the current rulemaking that we have by the Biden administration, as well as future upcoming decisions in the courts and otherwise. So where do we get this term, waters of the United States? Well, it comes straight from the preamble of the Clean Water Act and the goals that are set forth for the entire statute. The first goal being to restore and maintain the chemical, physical, and biological integrity of the nation's waters. I'm sure everyone has seen that. It's in every rulemaking, guidance document, and court decision. But the next piece is the Act states that it is a national goal that the discharge of pollutants into navigable waters be eliminated by 1985. which didn't really happen, but the term we got from that is navigable waters, which is very helpfully defined by the statute as waters of the United States, spelling it all out for us. Because the definition is so nebulous and ambiguous, there's been a lot of attempts over the years through the courts and through the agencies to define what that means. And it turns out it doesn't mean actually navigable in fact, like you could float a boat on a stream. Those waterways are definitely jurisdictional, but it's the further removed waterways that are the source of most of the controversy. So it's important to define waters of the United States because it defines the jurisdictional reach of all programs under the Clean Water Act. So not only the Section 404 program, but the NIPSEA wastewater permitting program, spill prevention, the state certification process under 401, basically everything under the Act. And the lack of specificity in the statute itself has created uncertainty and attempts by both the EPA and the Corps, as well as the U.S. Supreme Court, to attempt to define the jurisdictional reach and the meaning of the statutory language over the years. So I'm going to go over the three seminal cases that have been decided by the U.S. Supreme Court under the Clean Water Act on defining waters of the U.S. As you'll see, this is important because it figures into the rulemaking. And also, we are going to have another round of the U.S. Supreme Court addressing this issue late this fall. First case is United States versus Riverside Bayview Homes. It's a 1985 case that interpreted the regulations in effect at the time, concerned a housing development on property near the shores of Lake St. Clair in Michigan. And the court actually sued there to enjoin construction because no 404 permit had been obtained. And the court contended that under its current regulations, the wetlands on the property were jurisdictional because they were adjacent wetlands adjacent to a traditionally navigable water, which would be Lake St. Clair. The Court of Appeals in that case actually reversed the Corps' original decision, saying that the wetlands were not jurisdictional because they weren't regularly inundated by water. But the Supreme Court ultimately upheld the Corps' extension of jurisdiction and upheld that jurisdiction under the Clean Water Act does extend to adjacent wetlands. The next case is the Swank case, or Solid Waste Agency of Northern Cook County versus the Corps of Engineers. A little bit different water feature involved here. This actually concerned a development of an abandoned sand and gravel pit, a large site that was going to be used as a solid waste disposal site. And it had several ponds, some large, some small on it, that were used by migratory birds. It was not adjacent to a large stream or tributary or lake. It just was being used, and the basis for the Corps extending jurisdiction was under its migratory bird protection rule, migratory bird rule, and the Corps held that the jurisdiction extended and that a 404 permit was required. In that case, the court reversed the Corps' determination and held that jurisdiction under the Clean Water Act does not extend to such isolated waters. And we had the first mention of there needing to be a significant nexus to traditionally navigable waters, larger waterways, in order for there to be jurisdiction. The third case is one I think probably everyone has heard about by now, and that's the Rapanos case versus the United States, decided in 2006. It's a very split decision and confusing to apply. Also, it concerned wetlands that were adjacent, or court contended adjacent to a larger lake, or actually a tributary in this case, and the property owner was trying to develop a shopping center there. And the court determined that those were two adjacent wetlands because they were adjacent to a tributary that had determined to be jurisdictional. In this case, we have the same decision coming from the justices, which was to uphold jurisdiction for this particular set of wetlands in this particular property, but very different reasoning from the justices here. The 4-vote majority, which is the decision joined by the most justices, would have required regular flowing or standing water for Clean Water Act jurisdiction, and would essentially have excluded many areas that under prior Corps regulations would have been considered jurisdictional and would have been dry parts of the year. But the deciding fifth vote came from Justice Kennedy, reiterated and extended that significant nexus test that we saw in the Swank case to say that jurisdiction only extends if a water body has a significant nexus to a traditionally navigable water or tributary. So very split decision. The court historically, since that and that decision in 2006 and the agencies have looked to the Kennedy test and the significant nexus test because he was the deciding vote in the majority upholding the court's decision. And this case is important because it continues to be addressed through several rulemakings. So we'll move on to the regulatory backdrop. In each of those cases, the Supreme Court reiterated that they expected to see the agencies do a formal rulemaking to address this, and so it wasn't the ambit of the courts to be making these definitions. The agencies have several times issued guidance documents that have been addressed in the case law, up to the Rapinos guidance in 2008. And the key issues are, as I said before, they're not arguments over whether a large water body like the Colorado, Mississippi River, the Great Lakes, whether those, which are traditionally navigable waters, would be jurisdictional or not. The controversy lies in tributaries. What is a tributary that is jurisdictional? What types of adjacent wetlands are jurisdictional? And does jurisdiction extend to other waters? The rulemakings have also attempted to address what is exempt from the Clean Water Act, and with varying interpretations on that as well. So the next slide summarizes about 7-8 years of administrative process and legal wrangling in one slide. 2015 Clean Water Rule was the Obama administration's proposed rulemaking, which was a fairly expansive definition of both tributaries, adjacent wetlands, and other waters. Over 1 million public comments were received on that rule. There were dozens of lawsuits filed to challenge it in both the district courts and appellate courts. The jurisdictional question went up to the Supreme Court. And then injunctions resulted as a result of that litigation that left us with a patchwork of states where the rule was in effect, states where there wasn't in effect. Ultimately, when the administration changed, priority of the Trump administration, and an early executive order was issued to repeal the rule. They first tried to rescind the Obama Clean Water Rule starting in 2016. That was ultimately enjoined by a court. And then they ultimately did a repeal rule in 2019. 2021 is the actual replacement rule that most of us are familiar with, I'm sure. It's the Navigable Waters Protection Rule that went into effect in June 2021. I won't get into all the details of that rule because it's no longer in effect, but just to highlight some of the major issues. Tributaries, the ephemeral streams that were precipitation dependent in a normal year were excluded from jurisdiction. So that excluded a lot of waterways, particularly in the arid west, that had traditionally been considered jurisdictional. They also tightened the standard for adjacent wetlands to wetlands that would have a continuous surface water connection to traditionally navigable waters, so really following that Scalia test in Rapanos with some exceptions. And they also eliminated the significant nexus test from Rapanos in the Navigable Waters Protection Rule. Fast forward to the Biden administration. This was also an early environmental priority, and an executive order was issued prioritizing the reversal and replacement of the Navigable Waters Protection Rule. The administration was helped by the Arizona District Court in August of 2021, which vacated the Navigable Waters Protection Rule nationwide, and the court placed processing any decisions under that on hold. And then December 7th, we have the current rulemaking that we're going to talk in more detail about. That is the first step of the Biden administration's attempt to address this issue, and essentially reverts back to the pre-2015 regulations, those original 1985-86 regulations, and attempts to codify the Rapanos standards, both of them. And the next one, so highlight, I'm not going to get into this. Daniel's going to cover the more technical details of this. Again, covers all what the rule calls foundational waters, but that's your traditionally navigable waters and most impoundments. And then really for tributaries, wetlands, and other waters, we have an incorporation of both the relatively permanent test by SWCA or the significant nexus test by Kennedy. So an incorporation of an either or standard for determining whether a tributary, and then on the next slide, a wetland is jurisdictional. And then a reversion back to this bordering, contiguous, or neighboring definition of adjacent. Neighboring has been a definition that has been addressed in previous rulemakings, but would be something that presumably would be addressed in future rulemakings. And then on the next slide, the Biden administration rule brings back this additional category of other waters that can also be considered jurisdictional, not tributaries or adjacent wetlands, but if they meet the relatively permanent or significant nexus test, they could be considered jurisdictional as well. On exemptions, both attempts by the Obama administration and the Biden administration outlined a number of exemptions, a lot of them raised during rulemaking and frankly hard fought by the industry group to get those expressly exempted. Those, for the purposes of this first rulemaking, the Biden administration, of course, has maintained the statutory exemptions in the Act, and then the two prior exemptions that were from the 1985-86 regulations for waste treatment systems for prior converted cropland. They've changed those somewhat, not maintained those, but the other exemptions that were addressed in both the Trump and Obama rulemakings would no longer be in the rule, but presumably would be addressed, and the agency has indicated would be addressed in a future rulemaking. So looking ahead, this is my very cynical lawyer slide, having dealt with this for over a decade. Comment period on the current pending rule closes on February 7th. That's a first step that would be finalized in the spring of 22. Presumably, we'll see litigation challenges to that. I think the Biden administration has been careful in the way it has crafted the two steps as a reversion back to the previous standards and then addressing the more controversial detailed aspects in a future rulemaking. But it's pretty likely that we're going to see some groups challenge that. And then we have a step two rulemaking likely coming in the future, or the administration has indicated is coming in the future, which will certainly lead to litigation. And to make it all more complicated, the Supreme Court yesterday granted certiorari in the Sackett case, which is a case concerning jurisdiction of a property in Priest Lake, Idaho. The Sackett couple is a couple that has been in litigation over WOTUS for pretty much the entire time since Rapinos. But they petitioned the Supreme Court to address what they characterize as a circuit split as to how Rapanos should be interpreted, and very strongly argued that the SWCA test should win out over the significant nexus test. Sort of a surprise that the case, the court decided to weigh in on that, and it kind of creates some open questions as to how the Biden administration will proceed and what ultimately the rule will look like if the court ends up changing that Rapanos standard. In considering the litigation, it's important to think and understand the regulatory backdrop under the Administrative Procedure Act. Any rulemaking that is done by an administrative agency has to follow that process, and it is not a fast one. Requires a notice and comment rulemaking that is supported by a very robust administrative record. So essentially, there are no shortcuts. That's why these are multi-year processes and things move very slowly in administrative law land. This is the standard that the Supreme Court has articulated when reviewing agency rulemakings, essentially that the agency must articulate a rational connection between the facts found and the choice made to really have support in that administrative record to withstand judicial review. In cases where the agency has previously addressed some subject matter and then come to a different conclusion, the rulemaking kind of has this heightened standard, which is outlined on the next slide, where the agency has to essentially provide a more detailed justification for why it's changing its position. And you see that already in the current rulemaking first step by the Biden administration with a careful explanation as to why they believe the Navigable Waters Protection Rule was not the appropriate standard under the statute. So I will turn it over to Daniel for more explanation on the current rulemaking.
Ashley, thank you for that great information and legal summary. Next up, we have Daniel, who's going to give us an overview of the existing regulations that are also referred to as the post-2008 Rapanos guidance, as well as the current rulemaking. And Daniel will be providing some additional technical information on how these existing and potential future regulations will affect how waters of the U.S. are delineated in the field. Daniel, are you ready?
Yeah, here I am, ready to go. Thank you, Noah. Thank you, Ashley, for that great introduction of the regulatory background. As Ashley mentioned, when the Clean Water Act was promulgated, they did not fully define what waters of the U.S. mean. So this question of where does a regulatory water end and dry land start has been debated ever since the beginning of the Clean Water Act. And you can see through, as Ashley described, the various rulemaking processes, the various Supreme Court decisions. It's been a complicated situation. With the latest two rules that have been repealed or vacated, the Clean Water Rule was repealed, and then the Navigable Waters Protection Rule has been vacated, and notice has been provided for publication of a new rule. That sends us back to the post-Rapanos waters of the U.S. regulations, or some people say the pre-2015 rules. Anyway, it's referring to how regulations were set out and implemented between the Rapanos decision and the 2015 Clean Water Rule. So foundational waters that have always been considered regulated as part of the Clean Water Act. Waters related to interstate commerce, traditional navigable waters, interstate waters, territorial seas, and then also tributaries, including relatively permanent waters and wetlands that are adjacent either to the relatively permanent waters or to the foundational waters. Then with the Rapanos decision, introduced the concept of significant nexus, building on the concept of significant nexus from the Swank decision. That recognized neighboring relatively permanent waters and adjacent wetlands. So that recognized intermittent or ephemeral streams and wetlands that are adjacent to ephemeral streams. So the relatively permanent waters include perennial streams, intermittent streams that flow seasonally and have a groundwater discharge that supports base flow. And then ephemeral streams that had a definable bed and bank could be considered part of the water bodies that had a significant nexus to a tributary. And then adjacent wetlands that were connected to the ephemeral streams were brought into jurisdiction under the significant nexus standard. And that's where we are right now in this interim period between the vacate of by the Arizona Court of the Navigable Waters Protection Rule and promulgation or finalization of the next waters of the U.S. definition. Excluded from the definition is in things like isolated waters and wetlands, and that's a result of the Swank Supreme Court decision that Ashley mentioned. Treatment ponds, ditches in uplands, prior converted cropland, and groundwater has never been part of the Clean Water Act. In November, the Biden administration proposed a new rule for waters of the U.S., and this rule would repeal the 2019 definition of waters of the U.S. under the Navigable Waters Protection Rule. That rule is vacated, but this would formally repeal it, and introduced a two-step process, and they describe it as a foundational rule to restore long-standing protection. So it's really essentially to codify the definition of waters of the U.S. that I just described in the previous slide. And then there's a second stage a second step that's described as issuance of a second ruling that builds on the regulatory foundation with additional input from stakeholders. And the Corps and the EPA have been a little bit vague on what that means. So we don't know really what shape that'll take. And a lot of it will depend on the final rule that they promulgate that's in the rulemaking process now. The foundational rule that has been proposed in November mostly adopts the 1986 definition with consideration of the Supreme Court decisions that Ashley mentioned. The proposed rule affirms the foundational waters, the traditional navigable waters, the interstate commerce waters, things like that. It also affirms the relatively permanent waters. And then it goes a little bit further to define significant nexus. And currently, using the standard of this significant nexus as defined in post-Rapanos regulations, or no, guidance documents, I shouldn't say regulations, in guidance documents and in the Kennedy opinion from the Rapanos decision, that significant nexus depends on chemical, physical, and biological effects on traditional navigable waters. And the proposed rule changes that wording a little bit to be chemical, physical, or biological effect on traditional navigable waters. So that slight definition could have some big implications on how significant nexus is applied. Also, in this proposed rule, they're soliciting comments regarding significant nexus. And Justice Kennedy when he talked about significant nexus in the Rapanos decision, he talked about similarly situated waters in the region may need to be considered in determination of significant nexus, but there's never been a definition, at least promulgated through a formal rulemaking process, to define similarly situated waters or to define region. And the Corps and EPA are also soliciting input on types of functions to evaluate. So they proposed a rule. There's still a lot that we don't know about the final shape that will take, partly because there's some ambiguity in what they're saying, and partly because they're still actively seeking public comment. And as I actually mentioned, that public comment periods ends on February 7th. So you still have an opportunity to provide input on those proposed regulations if you'd like. One other thing to note about the proposed rule is that it addresses non-navigable, non-wetland waters. And currently that jurisdiction applies only to certain tributaries, and the proposed rule would apply jurisdiction to certain tributaries and non-tributaries that have a significant nexus to a traditional navigable water. So that might include an oxbow lake on a floodplain that's otherwise surrounded by upland, or an abandoned gravel pit, something like that on a floodplain, where because of the potential for flooding, you could say there's a significant nexus where there's not a relatively permanent surface water connection to those water bodies.
Thanks, Daniel. A lot around the corner for us to dig into more. Next up, we have John Heule. John is a professional wetland scientist in our SWCA Denver, Colorado office. John holds an environmental policy and management degree with over 7 years experience in environmental consulting. And he will be discussing the upcoming nationwide permit program with the Army Corps, as well as new considerations there.
Thanks so much, Bonnie. And I'd like to start with an overview of what nationwide permits are. They're a type of general permit, meaning that they're not project specific, and they authorize the placement of dredged or fill material into waters of the United States. They satisfy requirements under the National Environmental Policy Act as an environmental assessment, and they sometimes require notification for their use to the Army Corps of Engineers, and sometimes do not, depending on the type of permit and activity that's being authorized. In order to understand the 2022 nationwide permits and why they're proposed to be renewed, we need to go back all the way to the 2017 nationwide permits, which is the last time that nationwide permits were renewed on their regular 5-year interval. In 2017, there were 54 different nationwide permits, and they were proposed to expire in March of 2022. However, in late 2020, the Army Corps of Engineers proposed a mixed bag of reissued and new nationwide permits and ended up approving 16 permits. Those are listed in the table below. And most notable of these changes was Nationwide Permit 12, which limited approval for Nationwide Permit 12 only for oil and natural gas pipelines, rather than electric utilities or water utilities. Nationwide Permit 12 was changed so that there is only 3 triggers for notification to the Army Corps of Engineers, and new oil or natural gas lines greater than 250 miles in length would now require notification. Electric utilities would be approved under Nationwide Permit 57, and water utilities approved under Nationwide 58. The limits and notification requirements generally were similar to the Nationwide Permit 12, but those are separate permits. And nationwide permits 55 and 56, next slide, would apply to seaweed and finfish mariculture activities, and notification required for both of those. So again, those are a high level overview of some of the changes for the 2021 nationwide permits. In addition, the Army Corps of Engineers proposed changes to the general conditions for nationwide permits, and these only applied to the 2021 nationwide permits. Some of the notable changes there: a removal of the 300 linear foot limit for losses of streambed for several nationwide permits, additional waiver provisions allowing the district engineer to waive limits for some of the provisions of nationwide permits, changes to general condition 20, indicating that nationwide impacts that might trigger notification, or that might trigger impacts to historic rivers rather than may cause impacts to historic resources, would require notification. And again, to general condition 23, and you can move to that. There's the nationwide permit activity might have the potential to cause impacts, and it used to be may. We can talk about how different projects might trigger a notification or that or not. But the Corps was trying to align this language to their own 106 consultation requirements. And under general condition 23, mitigation is now required for 3/100ths of an acre of streambed loss if notification is required. And note that the loss of 3/100ths of an acre or more is not in itself a notification trigger. So kind of interesting to see how that one was worded. So that left us with several permits that were set to expire in March of 2022. And in last month, December of 2021, the Army Corps of Engineers proposed to renew those nationwide permits with a few changes. And the next slide kind of summarizes some of those changes. Several of the permits, the wording added examples of activities that would be approved under those specific permits to nationwide permits 14, 27, and 41. There is a change in the definition of low head dams for nationwide permit 53, and a new nationwide permit 59 for water reclamation and reuse facilities. The general conditions approved in 2021 now will apply to all of the 2022 and 2021 nationwide permits. So those are listed here again: the 300 linear foot limit for losses of streambed, additional waiver provisions, minor changes to general condition 20, and the mitigation requirement for 3/100ths of an acre of streambed impact. So those will now apply to all of the nationwide permits when they go into effect in February. Last, what happens to nationwide permits as nationwide permit verifications as these previous permits expire and the new permits are approved? The 2022 nationwide permits will go into effect on February 25th. Projects authorized under a 2017 nationwide permit are authorized until they expire. In general, that is March 18th, 2022, unless a specific verification lists a different expiration date. So check your verification, use the date on that. And then projects authorized under a 2017 nationwide permit, which are no longer applicable under corresponding 2021 or 2022 nationwide permits, are still valid for 12 months as long as those activities have commenced. So for example, a electric utility line activity, which was approved under a nationwide permit 12 before that change, would still be in effect for 12 months. That's what I have on nationwide permit updates.
Thanks, John. That's great information. Well, we've got some questions coming in, but before we shift to the attendee submitted questions. We have some panel discussion questions that we have queued up. Bonnie, would you like to pose the first question?
Absolutely. This first question is a common one we're getting. And the question is the recently vacated 2020 water quality certification rule still affecting the Army Corps nationwide permit verifications, given its status? So Ashley, can you was with that one?
Yeah. I think that the short answer is yes, in some cases, and without getting into a ton of detail, which is necessary, I think it's important to check the status of the 401 review of the nationwide permit that you're using. For those of you who may not be familiar, the Trump, in addition to all the other rulemaking and the WOTUS rulemaking, the Trump administration also did a revised set of regulations implementing the Section 401 water quality certification that states do. Typically, for a nationwide permit, they will do a programmatic approval of those nationwide permits that impose state conditions under the 401 process. Trump administration, so some of the prior nationwide permits were approved or conditioned or not approved by the states under those rules, under the Trump administration rule, and the Trump administration rule was also recently enjoined by a court. So we're reverting back to the prior regulations, but in some cases, states that didn't approve nationwides under 401 were reserved that may do that in the future. But I think in some cases, depending on which nationwide permit you're using and depending on the project, depending on the state, it's important to check the status of that and then just ensure that a 401 approval has been issued. And if not, figure out what you need to do.
Thanks, Ashley.
For the next question, and this always comes up anytime the regulations change, where you have a decision made under one set of regulations and then those regulations are either repealed or changed. I'm interested to know, for projects that received an approved jurisdictional determination under the Navigable Waters Protection Rule, that was the rule that was promulgated under Trump that was recently vacated. Is there a risk that the Corps of Engineers will rescind those determinations or revisit those determinations? And Daniel, I'd like your thoughts on this first.
Thank you, Noah. The answer is yes, there is a risk. And in some cases, there's more than a risk, there's a certainty. To give a little bit of background on that, an approved jurisdictional determination is a document that's issued by the Corps of Engineers in response to a aquatic resources delineation when there are water features that have been identified that do not fit under the definitions of waters of the U.S. And so a project proponent can ask the Corps to give them an approved jurisdictional determination that says certain features are waters of the U.S. and certain features are not waters of the U.S. And that provides some certainty for permitting going forward, that any impacts to things that are waters of the U.S., they would need a permit that's such as the nationwide permits that John just talked about. With the vacate of the Navigable Waters Protection Rule, the Corps of Engineers has issued a policy or made an announcement on January 5th that they will revisit some of those approved jurisdictional determinations. So they announced that where there are permit decisions that are going to be made now going forward, they will revisit those approved jurisdictional determinations and may revise them. So from a practical standpoint, somebody building a project, whatever it is, there may have been water bodies or wetlands that were determined to not be part of the waters of the U.S. under Navigable Waters Protection Rules. So for, however many months that's since the approved jurisdictional determination has been issued, it seemed like those water bodies or wetlands did not require a permit for dredge and fill activities. Well, by rescinding the approved jurisdictional determination and reissuing a new approved jurisdictional determination, some of those water bodies and features will require a permit. They will be considered waters of the U.S. under the current regulatory framework, which is the post-Rapanos framework.
Thanks, Daniel. That's really good. Now, I'd like, Ashley, I'd like you to give some of your legal perspective on this in terms of where do project owners have risk versus where should they feel protected to move forward with work either permitted or no permit required based on these AJDs performed under the Navigable Waters Protection Rule?
Yeah, well, this is sort of a moving target, and it's a bit unprecedented. I think what the Corps has actually gone ahead and announced in some of the outreach that they're doing to rescind those prior determinations. I think it's always, as you noted, Noah, been a concern when we have this regulatory whiplash, so to speak, back and forth on interpretation of a statute to have folks stuck in the middle of that. There's always a concern of what the retroactive effect of a new rulemaking is. And the Corps has always had language in its AJD process allowing for an AJD to be reopened based on new information. But I think, in my experience, that it's been unprecedented for the Corps to actually announce that they're going to re-examine previous determinations based solely on what is a change in law and not a change in new information. So I think it really merits, depending on the specifics of your project, if you have a project stuck in the middle of this back and forth, to really consult with your technical and legal experts on what your risks are, because I think they vary depending on the project and depending on the public interest in your project. Potential for citizen suits is also a concern under the Act. So there's not, unfortunately, an easy answer to that, given what the agency has indicated. I think in some cases there may be a legal ground to challenge decisions depending on the particular circumstances. So it's a dicey predicament, and unfortunate for a lot of projects that put a lot of resources into processing permits under what was the rule at the time.
Thanks, Ashley. It sounds like there's a lot of uncertainty, and a lot of this is it comes down to the devil's in the details.
Okay, we have our third question, which is related to future SCOTUS decisions. So how could the future regulations affect the definition of waters of the United States? And what about timing? And I'm hoping to kick that one to you again, Ashley.
Yeah, so another kind of open question. The court just accepted cert on this case yesterday. I think the longer it sat on the case, the more we all were concerned that they would actually take it. But it was still a bit of a surprise that they decided to weigh in on this, given that I think it was debatable whether there actually was a circuit split on the issue of the interpretation of Rapinos. But I think it has the potential to throw a real monkey wrench in what the Biden administration is doing, particularly because their first proposed rule is to codify both tests under the Rapinos decision. So by accepting the case, the Supreme Court is potentially signaling that they may be inclined to do away with the significant nexus test and rely solely on the Scalia decision that would require relatively permanent standing water. So we don't know what the justices are thinking. We can predict what the votes would be, and it's possible that the court could limit the effect of its ruling. But by wading in and looking at the substance of Rapinos and how it should be interpreted, it has the potential to really corral what the EPA is doing. And I think we already have House representatives and senators arguing that the EPA should just table the whole thing and wait for the Supreme Court, which of course the EPA does not agree with. But we'll see a lot of wrangling over that, I suspect, in the next few months. As for timing, the court likely would not be able to issue a decision on this, or at least until fall, maybe later. There will be a whole briefing process and schedule that has not come out yet on that, but I think October is the time frame that was the best guesstimate at this point. So that puts you in a real limbo if you're the Biden administration trying to advance this and define a definition based on Supreme Court precedent that now the court has indicated it may change.
Thanks, Ashley. Now we're going to move into some questions and answers, and we've received a lot of great questions via the Q&A chat button. Please keep submitting those. Whatever we don't get to today, we'll try to follow up with individuals after the event. I also would just like to identify that we have our email addresses on this slide. If you do have questions that you would like to ask offline, please feel free to reach out to any one of us. We're all excited to interact with folks on these questions. John, I'm going to direct the first question to you, and I know that you answered this in the chat, but I'd like to hear a little bit more. We had a question about cases where waters of the U.S. and there's tributaries or canals or natural channels are used to move water from a large water body to another and wetlands due to seepage, and are these jurisdictional? And I was wondering if under the existing regulations, which are very similar to the proposed regulations, what can you say about canals and ditches and whether or not they are waters of the U.S.? What are some of the things that you think about when you go look at those sites?
I wanted to just reiterate something that Daniel said in relation to this question, but also just because I think it was really important. And we didn't, we were moving through that kind of quickly. So just to reiterate that the proposal includes for a significant nexus determination, waters that have a physical, chemical, or biological nexus to other waters of the U.S. can be told was and, so you'd have to have all three. So that's one thing that I noted in the chat and an important part of this. The way I do think about, especially this question, if you have two waters of the U.S. And a canal or a stream is connecting those two, it's likely that that third one is a water of the U.S. And then as far as wetlands that are around those waters of the U.S., if those have a physical, biological, and a physical, biological and chemical connection, then that can be a water of the U.S. as well.
Great, thanks, John. We have another question, John, that maybe you can help clarify regarding the 2021 general conditions, and will those be in effect for the 2022 new nationwide permits, thereby, consolidating the nationwide permits to have one set of general conditions?
Yes, the answer to that is yes. So all of the 2021, the proposed general conditions in 2021 will now apply to all of the nationwide permits. So there won't be multiple sets of general conditions. And also, I think most notably, the 3/100ths of an acre of stream bed loss will apply to trigger for mitigation will apply to all of the nationwide permits.
So we have a question here, and I'll put this out to the panel to see if anyone takes the bait, but we have a question about project commencement language, and that it appears to be vague and subject to district engineer prerogative. And as we approach the expiration of these 2017 nationwide permits, permittees require some clarification about whether or not they are good to move forward with their project, or do they need to go back and get confirmation. Daniel, Ashley, John, Bonnie, do any of you have any guidance on what permittees can do to avoid delays, but also continue to move forward?
I can take a stab at that. Yeah, and Daniel, chime in too from your perspective. I think given kind of the dicey situation some of these are in and the vagueness in the regulations, I think, for controversial projects which are usually the ones that I get involved in, we have gone out of the way to confirm things in writing with the Corps, which even if you're not doing a pre-construction notice and you're under the threshold for that, have done, more, I guess, have more conversations and done more confirmation, which I know is hard when they have a huge workload like they do right now, but at least putting something in writing has helped clients have a bit more comfort on that. So we've done a fair amount of that, but again, I think it depends on the individual circumstances and which nationwide permit, and getting, I think some guidance on what your risk is so that you can proceed and get things done. We're doing a lot of that with clients right now and just trying to figure out what we need to do to feel comfortable proceeding and making sure we're in compliance.
Great, thanks, Ashley. John, I believe you indicated that you could help us answer this question about stream bed alteration permit requirements and anticipated future changes or recent changes that folks should be aware of.
Well, and I apologize if I'm misunderstanding the question, but several states do have permits for alterations to streams in addition, above and beyond the waters of the U.S. Requirements. And so those are regulated at the state level, and there are likely changes that I may not know about that are outside of my regular purview or geographic area of work. But in general, these topics would not change those permitting requirements other than if a water is jurisdictional on the federal level or not jurisdictional on the federal level. Sometimes the state permit would coordinate closely with the Army Corps of Engineers to approve that project at the same time. And if a federal permit was no longer needed or would be needed, that coordination might change.
Great, thanks, John. We have another question here about regional conditions, and someone's identified that in Texas, the regional offices had proposed new conditions, but not all of them were implemented in 2021, presumably because the underlying nationwide permits were not reissued. And it sounds like they may revisit this before February, the effective date. Does anyone on this panel have any awareness of regional conditions that are being adopted at the state level?
No, I haven't heard anything yet in the upper Midwest in relation to the new nationwides. In my experience, it seems like they usually come out, after the nationwides are finalized.
Great, yeah, thanks, Daniel. That's been my understanding as well. Well, I think we've gone through most of the questions that we're going to be able to answer today. I would again like to thank everyone for attending today. The webinar will be available online, so if you weren't able to take notes while we were speaking quickly or covering some dense information, please, you can find the link either on swca.com or on YouTube. You can always follow up with additional questions to us via email. And again, thank you all for taking some time out of your day. We look forward to seeing and working with you in 2022.